Malema.
No, thank you very much, CJ. I just want to make a follow-up on the questions the CJ asked. Maybe put differently. Judge, when are you retiring?
I'm told, I believe 1 June, it should be 1 June 2024. A year and a bit, that's all.
1 June 2024.
Correct.
Now, you saying you are told. I want you to tell me, because you should be knowing yourself, when are you retiring?
I asked, sorry, Commissioner Malema, I had asked about a month and a bit ago, what is my actual retirement date? I am waiting for a response. I have not received it. The calculation is that my appointment, my letter of appointment came through on 26 August 2009. I know this because it was 2 days before my birthday. That's not because I have a great recall. Just happened to be that. My acting appointment, I had acted from 1 June, and as I understood it, as long as you act continually until your appointment, that is taken as the period. So that's why I believe 1 June, but there may be considerations that may or may not advance it. But I believe 1 June is on paper the appropriate date. There were earlier acting stints. I don't know if they're taking into account. I'd understood it's your permanent, continual acting period. So that's why, my apologies. That's why I can't be definite. What I can definitely say is it is no later than 1 June 2024.
I know it's our responsibility to decide to appoint you or not to appoint you. I mean, to recommend to the president to appoint you or not to appoint you. But do you think it's fair for this body to recommend to the president to appoint a person who's going to serve for less than a year in a court where we're actually struggling even to get people? If we appoint you and you go on retirement, it's almost going back to square one. So, in all fairness, and if we recommend you, we are going to recommend you now is April. We don't know when the president is going to appoint you. He takes his own time. He might appoint you in June, after June. He just appointed now the SABC board. It took forever for him to appoint that board. So it might take whatever period for him to appoint you. And that becomes less than a year into retirement. Really, do you think it is fair for not that you are appointing, but in helping this commission to come up with a good decision? Because after we take a decision of appointing, we'll get subjected to scrutiny. We get criticized, we get applauded and all of that. Do you think it's the right thing to do at this stage?
Fair enough. Thank you for the question. I see fairness slightly differently. If I was competing, there are 5 vacancies. If there were 5 candidates standing, I would not have applied, because I would have taken a position where somebody else could have gained that experience in long term. So I see fairness from that perspective. There are 2 candidates and there are 5 vacancies.
But what do you do to the fiscus? I mean, you are going to get some increase for a position that you almost served for less than a year. Sorry. And then you go for the rest of your life with that package. What do you say to the fiscus?
May I assist
yes.
Then? The starting point is that there is no extra remuneration. So if that was a perception by anyone who's not a judge, then if I could assist there, and I'm sure the judge presidents will confirm that, there is no extra remuneration. There is only extra work.
Okay.
Nothing more.
Now the last one, CJ, through your indulgence, the complaint, I know you don't know the merits of the complaint and all of that. And the same happens to all of us, that this complaint is here. We can't do anything about it. We can't say it is a strong case or serious allegations or anything of that sort. And I also don't know, because when they say there is a complaint, in the absence of anything before us, we then Google you, then there will be this tax issue, or maybe we don't know what
Sorry,
the issue.
What issue? My apologies.
No, I'm saying I'm not saying there's an issue on you. I'm saying if I were to Google you, and then they say there is a tax issue about you, I didn't Google you, or there is sexual harassment against you, or there's GBV against you. I don't know what the complaint is, but the complaint is firmly there. It's there. It's undisputed. The JSC, they've received the complaint, and the problem is that on our side, the matter is not being resolved, right? And we also don't know what the issues. Will it be fair for us to appoint you without knowing even the merits of the complaint? Because it is undisputed that there is a complaint. It is undisputed. And only after we appoint you, the details, because remember, that's why we said this matter, if it can be resolved outside, let it be resolved, because we didn't want to raise this out of respect in the presence of the media. But once they hear now that there is a complaint against you, then they go and dig up on the complaint, and boom, here we have appointed a person who's accused of serious violations. Will it be fair for this body to appoint you with this complaint that it is before us? Or should we wait and say, let's have the matter resolved, and then we can look into your candidature, perhaps, if it's possible? Thanks, CJ.
Thank you. The OCJ had 2 years to find this. I wrote. It's there. It's on the application, and the correspondence is attached at the end. I glanced at it. The only complaint, sorry, I can't say only complaint. The complaint is regarding a delay in a judgment, delivering of a judgment. That's all. It's got nothing to do with my behavior. It's got nothing to do with anything else. So, I believe my record is good in delivering of judgments. I'd like to know what year that was, but I don't think it's current. And I believe that the profession as a whole, through their input, considers me to be courteous, considers me to be hardworking, diligent, applying. So it appears to be a matter concerning a long outstanding judgment at that time. But again, perhaps the Chief Justice can assist us to the year when the complaint was lodged.
Won't be part of it. CJ asked a question that what will be the difference acting now till your retirement and being appointed permanent? And I want to confirm what was your actual response to that question.
Fairness. Fairness. A person who, right from the beginning, had been identified while at the bar as having the capability of being in that court, not being given that opportunity right through my career. And eventually, through Judge Victor, 2 years ago, I think, when she was acting, and then Judge Valley when he was acting, there were no cases that came through for me at that time. So I've been waiting, and I've been sitting, and I've been waiting. It's your call. I'm not going to go with that further. It's a matter of fairness, as you perceive that fairness, as to whether there should be some form of recognition to being in that court, or whether it's going to be an acting. I'm not making that call.
Thanks. Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Baloyi? Sorry? Follow up? Okay. Commissioner Malema?
Thank you. No, let me understand this. That you have been identified from the bar and then this has not been happening and all of that, then you say fairness. Do you think you are entitled to this
No.
position?
No.
Because
No,
that
it's-
explanation comes across as saying, I'm entitled to this
No.
position.
Not at all. It's
Yeah.
something for you to consider. I'm just raising it. I'm not saying one way or the other.
Okay,
Thank you.
thank you.
Thank you. Another follow-up? Okay.
It's a quick one, CJ. Have you applied for this position before?
Yes,
Which year was it?
I think 2 years ago.
The same position of this?
I believe so,
applied for?
yes.
Okay, I missed that point. Thanks.
Thank you. Thank you. Commissioner Baloyi first. Can we accept that after they'd gone on your suggestion to do the inspection, they never came both parties to you and said, we have resolved the matter? You heard through some source that they'd resolved it.
Correct.
But that's not acceptable.
Okay.
You can't have parties before you who have a dispute and they bring the dispute as an urgent dispute. You're supposed to resolve it. You hear argument, they go away, and you hear from somebody that the matter was resolved, and as a judge who was dealing with the matter, you never do anything to get the parties back to confirm to you that the matter was resolved.
That if I'm wrong, well, I'm wrong, but nobody until this complaint has ever asked me, where's the judgment or anything like that, neither party. So my assumption was that it had been sorted out.
Okay, you can see I've been battling to try and finalize, but Commissioner Malema
sure.
and the Prof.
Judge, which procedure is that one that after arguments and everything else, instead of issuing for judgment, someone must come and tell you to issue a judgment? Which procedure are you referring to?
No, I'm not referring to any procedure, but if a party or something slips by, then you will get some notification saying, we're awaiting a judgment, nothing has happened. You said you were reserving, we haven't heard it. Nothing like that happened.
No. You owe us justice. We came before you, we argued, and you know it's the practice of the practitioners respecting judges. You can't be saying to the judge, when are you delivering? Because there's no such a procedure anyway. You can't refer me to any procedure. In the absence of that, are you saying for as long as there's no one who says where's the judgment, you will never issue a judgment?
No, that's not what I'm saying. What I'm saying is that I understood that through when the argument proceeded, because clearly there was argument after the inspection, I identified what was really there, what was at stake, and what was at stake had been resolved. Because through argument, it was accepted that these people were in fact there, this group, and another group, I can't remember, 3 or 4, were not there. That was it.
And you hear from someone that we're not even told about, that the matter has been resolved, meaning that you heard it from a gossip.
No,
Because the only procedural
My
way,
apologies.
if it's not gossip, even if it's written in the papers, you can't even cite that as a judge. Whereas an unidentifiable body, the only procedure is that they must come before you and say we have resolved the matter. They've never come before you, and in the absence of them coming before you, what do you do as a judge? Because there are a lot of young practitioners who are listening here. They are learning through this process. If the parties before you don't come to you to say we have resolved the matter, what do you do as a judge? Do you go and hear things through a grapevine? Do you go and read about them in the papers? What do you do for as long as the two because you are a court as you sit there, As long as the court has not been told by the parties interested that they've not resolved the matter, what is the procedure?
That is why I was hoping to get that recording, because it was
No,
in that
Judge
process the
Judge
various
Spears,
council.
I'm going to interrupt you, I'm sorry. The question is simple. What do you do in this situation? What procedure do you follow? The answer should be, this is the procedure. If you know it, if you don't know it, I don't know what procedure is applicable.
No, thank you. But it was prefaced on the basis that it's gossip. It wasn't gossip. It was the parties themselves during that hearing.
No, but Commissioner Malema is talking about after the inspection. He says they didn't come back to you, both parties, to say we have resolved the matter. And he's asking, where that has not happened, what procedure do you follow as a judge?
But before he answered, Chief Justice, you said to him, you heard from someone.
Yes.
And he
yes,
confirmed that he heard
yes,
from someone.
yes.
So he can't now say he heard from the parties. He said he heard from someone, and then that the parties have resolved the matter. I'm saying you cannot hear from someone or the paper other than the parties which appeared before you. In a situation where the two parties say, where the two parties never said to you in court that we have resolved this matter, even if you hear it outside, as long as these two have not come before you, what is the way forward?
Okay. All right. The facts of this was that there was an inspection. I wasn't sure when we started this discussion whether the argument was before and after the inspection or just before the inspection. The Commissioner pointed out that the complaint indicated that there was argument afterwards, so I accepted that. So trying to recall what happened. They have their inspection, they come back. One of the council adopts a high-handed attitude effectively regarding, yes, but we've always had this position. I then flesh it out between them, and the outcome is there's an acceptance that those identified at that inspection who had a structure there could not have been demolished, because the city's case was that they never demolished any structure that was there. The outcome of the inspection showed that there had been a demolition. Those people, the occupants, had been then identified. There were others, 3 or 4, where weren't. During that argument, it was accepted that those, because that was the city's case. If you had a structure, we couldn't have demolished it. We couldn't. And it's clear because that's the law. So it was from the parties themselves during the argument where that arose. So it is hearing when that argument took place, because I believe there was argument before and after having been told what that complaint is. It wasn't just before. There was a sequence of argument, yes.
But Judge Spill, if you now say that this is what was said during the argument that took place after the inspection, that there was an acceptance by one of the sides of certain proposition, if they didn't tell you at that hearing that the matter was resolved, on what basis did you not give an order or decision if there was no settlement agreement? Because it seems to me from what you are saying that earlier on you suggested that they should do an inspection, which they went and did. Then they came back and presented argument before you. During the argument, one of the parties accepted a certain proposition from the other side. But they didn't say to you, we have resolved the matter. And if they didn't say we have resolved the matter, on what basis did you not give an order or judgment then?
Chief Justice, I'm going back a bit, but my recollection, and it may be faulty, but that is my recollection, is that in engaging, it was accepted by the parties that those who had demolished had been demolished and they were identified, they could, the application was to stop an eviction or to allow them to go back or whatever. And I was comfortable that that had taken place. So I accept that I should have made a note, but I'd understood that it had been resolved, and the fact that nobody came back indicates to me that it had been sorted out and my understanding was correct.
But come back from where? Because the inspection had happened before
Yes.
the second time of argument. So they were to come back from doing what? The second time when they came back to argue, there had been an inspection. They argued.
There was a pig-headed,
There was some-
sorry, there was, I mustn't use that term. There was an attitude adopted by certain council that did not make sense, and I then fleshed it out, and then it was accepted.
But at the end of that session, did they say we have resolved the matter?
No, I'd understood that they had. They did not say so expressly. I'd understood that they had
They had-
identified and had worked out through the problem and through my engagement with them.
So they had an argument before you for you to decide the matter. They left without saying they have resolved the matter, and they did not say you don't have to make an order. They didn't say you don't have to give a judgment, but you decided not to give a judgment because during argument, some proposition was accepted.
Yes, they had accepted that this was the rational way, that you can identify who the people were, and that was it.
Okay, I think.
CJ.
Oh, okay. I'm sorry.
Yeah. CJ, I was just, you took from me when I was doing
You want a follow-up?
that follow-up, yeah.
Okay.
So now, we are now agreeing that
Sorry.
what the CJ was saying to you, which you agreed to, that you heard it from someone, it doesn't exist. It's not true. It's not correct. You didn't hear from someone that there was a settlement.
No, it was during the course of the arguing and putting positions or putting my concerns or putting my understanding to the parties.
So now I'm saying you are leaving that one, that argument that we were saying you heard from someone that they've resolved.
No, I don't believe I ever said that.
You said that the CJ said to you, you heard it from someone. And you said, I heard it from someone that the parties have resolved this matter. We are leaving that one.
No, I don't recall saying it. I don't believe I said it. If I did, it was always incorrect if I did say it. But my recollection is that it was after the inspection, but it was always the parties themselves who were before me. And I certainly didn't hear from anyone other than, or make any assumptions other than from what was put to me and what was argued before me and their responses, but it was only the council involved.
Yeah,
So
but-
there's no misunderstanding on that. There was no third party.
So let's leave that one. Even on this one, the parties have never said to you, we have resolved this matter. They've never said that.
Not expressly. I understood that they had.
Eh?
Not
What-
expressly, no. Not
I
expressly.
might not understand those things of expressly, and I'm not a lawyer, I'm a layman. I want to live here and go and explain properly.
Yeah.
No one ever said to you, we have resolved this matter, of the parties.
Sorry, can I just try and recall? I may have put, then, is there any issue where A, B, and C are accepted, D, E, and F are accepted? And that's it. You know, my difficulty is that I've tried to get correspondence that preceded this, because there was correspondence that preceded this, but I can't.
No, Judge.
If I may, sorry, my apologies. I don't mean to be disrespectful.
No, I hear you, but I'm saying to you, in your own ways, there's nothing wrong with accepting that, the version you have put to us. I'm trying to put it in a layman's perspective. That which you are doing now, of trying to say, you have said this, and then you have said that, you all do that all the time. And then Mugai Tobe and them will say, no, the other party has conceded, the other party has. Conceding and not conceding does not mean you can't deliver judgment, or you conclude that now the other party, because it conceded, it means now there is an agreement. And then there must not be a judgment. You know that. That is not how the procedure is followed. All I'm saying is, as they were busy conceding to you, as you put them to this side and put to this side, they were conceding to you. None of them, at the end of those concessions, none has ever said to you, we have now resolved this matter through your wonderful intervention.
No.
No
that's
one
correct.
said that.
That's
Yes.
quite correct.
Thank you.